All right, well, welcome, Luke. Thank you for having us. Flatwater Bank, thank you for having us. Hopefully you are here today because what you do at least maybe touches on employment law. Maybe one of the hats you wear at your organization is part HR related, or maybe you just wanted to learn something new today. It is our goal for you to walk out of this conference room at the end of this hour and say to yourselves, I have at least one golden nugget that I have taken away. Maybe there'll be more, but our goal is that you walk away with at least one thing that you learned today. We'll see. You are welcome throughout the presentation to ask us any questions. Don't feel like you have to wait until the very end. Happy to entertain any questions throughout. Because we are lawyers, we'll tell you that you can present any question to us as a hypothetical, and then we will answer your hypothetical. We're not really supposed to give legal advice if we don't have a client relationship with you, but certainly we can talk about hypotheticals. So feel free to interject throughout.
For example, hypothetically, I had this employee who hasn't shown up for work for like 2 weeks. What can I do? That'd be a good question. We can help you answer that.
I know that there are some participants who are participating remotely. If anyone who is participating remotely has any questions, there's a chat box that's being monitored. So feel free to route your questions online and those can be recited to us and we can answer them as well. So
That's us.
That's us. On this slide, I'm Tara. That's Mark. We are going to start off with a little lesson, and Mark and I were joking a little bit on the way here. Mark is going to teach you everything you need to know about employment law in 5 minutes. So if you want to test him, somebody start a stop clock.
Actually, don't do the stop clock. We won't be right at 5 minutes, but I have the fortunate opportunity occasionally to be the adjunct professor at the University of Nebraska College of Law, teaching the employment law course. So these law students spend an entire semester learning about all the intricacies of employment law. I'm going to tell you, I can literally summarize that entire class into about 5 minutes. That's what we're going to do here right now. Here is the start here. There's employment law and there's labor law. Those are not the same thing. Because they overlap, even though we sometimes refer to them as workplace laws, both of those laws kind of apply to the modern workplace. Employment law deals with such things as contract, discrimination, employment at will. Labor law is generally in the unionized settings. We hear labor law, that's generally when you're dealing with the union or folks who are employed pursuant to a collective bargaining agreement. We'll touch upon that a little bit as it relates to those in the room. Whether you're unionized or not, it still may apply to you. Right now, I'm going to talk about employment law. The foundation of all employment law in the United States is a doctrine called employment at will. It literally came over from Old England when we first built our legal system here in the United States. And here's what it says: that when there is no definite duration of the relationship, it's indefinite, it doesn't end after 6 months, a year, 2 years, whatever. There's no agreement on that from the outset. Then both the employer and the employee, in the old law, the master and the servant, true. The employer and the employee are free to terminate that relationship at any time, for any reason whatsoever. In the old cases, even said for a cause that's morally wrong. Meaning, under a pure, strict definition of employment at will, which is the foundation of all employment law in the United States, if there's no definite duration to the relationship, such as a year, that both parties can terminate for any reason whatsoever or no reason, even bad reasons. It's freedom of contract. So that is the foundation of that. That remains the foundation. We're going to talk about the exceptions here in a second. That remains the foundation of all employment law in the United States. There's only one state in the United States that does not continue to recognize employment at will. Does anyone know what that state is?
Don't guess California, you'd be wrong.
That is not the answer. Colorado. You would think so. They're getting a little goofy on employment laws, but that's not it. Close though. Reasons geographically. Montana. Montana has adopted a state statute that says after an employee has worked what's called a probationary period, which is 90 days, generally under the statute, then the only way you can fire an employee in the state of Montana is for cause, which is defined in the statute. The only state, even California, calls itself an employment at will state. So, okay, we now know you're right now, you're scratching your head and you say, wait, I know I can't fire someone because of their race or their sex or their disability. So how can that be the law that you can fire someone at any time for any reason whatsoever, or you as an employee can quit at any time for any reason whatsoever? That can't be the law. It is the law, but what happened is that courts and legislatures, Congress, state legislatures, even city councils have made or created exceptions to it. The first exception to the employment at will was created was in 1935. 1935, Congress adopted the National Labor Relations Act. It says, among other things, you can't fire an employee because he or she wants to be a member of a union. So it protected them. You can't fire union members. That continued. 1964. You cannot discriminate or terminate an employee because of their race, color, religion, sex, or national origin. 1967, age. You can't fire someone because of their age. Does anyone know under federal and Nebraska law what the magic age is when you're protected? 40. So that 17-year-old that comes in and says, I want a job, you say, I'm not hiring someone because of your age. They say, well, I'll sue for age discrimination. Good luck. You'll lose. They're not protected, so you get to be the age of 40. 67 was for age discrimination. Take it up to 1990. We have the Americans with Disabilities Act, which is adopted. You can't terminate someone because of their disability, which has a statutory definition, the three factors that they look at. So Congress adopted a bunch of exceptions to employment at will. State legislatures got into the act. Nebraska, after 1964, also said you can't fire someone, discriminate because of race, color, sex, religion, or national origin. But most of these states said, well, we're going to do what Congress did. We're going to add one. So Nebraska says you can't fire someone because of their marital status. It's illegal under Nebraska law. Go to California, they've added about 30 classes to that entire protected class, right? So as we're chipping away at the employment at will doctrine, it's getting pretty small, but it still represents the foundation. In addition to Congress on the federal level, state legislatures on the state level, city councils in some cities have adopted additional restrictions. City of Lincoln, Nebraska has done so. If you are an employer of 4 or more in the city of Lincoln, you cannot discriminate or terminate an employee because of their race, color, religion, sex, national origin, and ancestry. There's never been a case filed in the city of Lincoln that someone felt the need to protect, probably right after St. Patrick's Day, like we can't fire people because they're Irish. Who knows? Cities and other areas have adopted additional protected classes. So we got legislating, elected officials adopting laws, ordinances, chipping away at employment at will. At the same time, courts were being presented with some difficult cases. They said, well, yeah, it's employment at will, but that doesn't make sense here. One of the first ones that came about is what we call now public policy exceptions to employment at will. There's sort of 3 buckets under that, 3 types of cases, with courts, even Nebraska courts have said it's employment at will, but not when this happens. And there's 3 categories under that public policy. 1, if an employee is exercising a right or a privilege. For example, I'm working for my employer. I accidentally walk into a saw that lops off my leg, and I say, well, I'm going to file for work comp benefits. And the employer says, well, if you do that, you're fired. Well, statute says I get work comp benefits, so I'm exercising a right that I have by statute. You can't fire me for that. So courts, actually all 50 states now say, can't fire an employee for exercising a right or privilege that they have by law. The second bucket under that exception is the employee who's fulfilling an important legal or public obligation, jury duty. All 50 states, you can't fire an employee who's been called for jury duty and actually serves. So those are the 2 primary buckets. The other one is for refusal to commit an unlawful act. The classic case is employee. For those of you who here is old enough to remember the leaded versus unleaded fuel distinction. Yeah, there's only a few of us, right? So it used to be when they changed it from leaded to unleaded fuel, there's a catalytic converter in the car. If you put leaded fuel in that, it actually would burn out the catalytic converter, as opposed to having someone cut it off your car and steal it these days, right? That's what happens. So it's a violation of federal law to put leaded fuel in a car that was only meant for leaded fuel. Case out of Arkansas, customer pulls up. This is back in the days of full silver gas. Customer says, put leaded fuel in there, and the young employee says, well, I can't. It says unleaded only. Customer says, I'm like, I buy a lot of gas here, put that leaded fuel in. He goes, I can't. And so the box comes out, the owner, and says, put leaded fuel in his car. And the employee says, I can't, it's a violation of federal law. He goes, you're fired. So he fires him, and the employee said, all I was doing was complying with the law. Court said, yeah, we're gonna recognize an exception to employment law. So, 3 buckets: it's fulfilling an important public obligation such as jury duty, it's exercising a right or privilege such as seeking workers' compensation benefits, and the third is refusing to commit an unlawful act such as the gentleman in the case with the unleaded fuel. So that's one type of exception to employment at will. Courts have generally taken cases which present them with really difficult situations, right? There's a Nebraska case that created yet another exception to employment at will, what's called promissory estoppel. We're now one of 17 states that recognize this exception. Employee, I'm going to, it's actually a reported case, but it's close enough to here. I'm going to hide the facts a little bit so no one knows who these people are. Woman works in an OBGYN clinic in central Nebraska, and she's being recruited away. She's actually in an office capacity, an administrative capacity. The PD clinic down the road is trying to recruit her away. She says, I'm not interested. They come back to her repeatedly, say, we need you. What's going to take? Finally, she says, okay, I'll agree. So require a move in my family. So I want 6 months here to help hire my replacement, make sure there's a good transition, get my family moved to new Nebraska City, and then we'll do it. Let's assume this is earlier in this particular year. She gives the notice, hires a replacement, transitions to the replacement, family. And on the Friday before the Monday she is to start at her new OBGYN clinic, they call and say, yeah, we changed our mind. You're an employee at will. We can terminate you at any time for any reason whatsoever. So we're going to do it before you even start. Which says, well, that's not fair. So this goes all the way to the Nebraska Supreme Court. And the Nebraska Supreme Court says, that's not fair. And so we're going to recognize a situation where a promise is made to someone, and the person relies to their detriment on that promise. She gave up her job, moved her family all the way to this place. In that situation, we're going to say, you can't fire someone for that. But then the employer said, during the argument of the case, said, well, okay, we'll employ her for 1 day because she's an employee at will. We can fire her for any reason whatsoever. So we'll let her work 1 day and then be fired. And the court said, yeah, that's not fair either. You need to give her a good faith opportunity to actually do that job. Here's the takeaway. Employment at will remains the law of the land in 49 states, but legislatures and courts have continued to chip away at it so that not much is left anymore. Some of the things we're going to talk about here today are to help you understand those nuances. But at the end of the day, employment at will is the foundation. There are lots and lots and lots of exceptions to that. That is your 5-minute lesson on, maybe a little bit longer, on employment at will. Next big doctrine I want to talk about, it's kind of a law. It's really important. It's really complicated, despite being around since 1938. Some of you have worked in HR, worked in payroll, you've worked with this law, and you say it just doesn't make sense. And you're absolutely right. And here's why. It was adopted post-Depression era. It largely hasn't changed since then. So many of the doctrines, many of the rules, many of the regulations that we deal with really work in a different era in our country. And really Congress and the administrative bodies have been really unable to adapt them to the modern workplace. Fair Labor Standards Act 1938, there's 4 buckets in that. One, minimum wage. Who knows what the current federal minimum wage is? $7.25. Anyone here still hiring folks at $7.25? No. So the market has moved beyond the minimum wage. Most states, Nebraska included, we had a referendum on our ballot last fall, which passed, which is mandating increases. So states have moved on beyond the federal. So for all intents and purposes, the federal minimum wage is largely irrelevant. Overtime, very complicated issue. We'll talk about that a little more here in a second. Child labor, again, those under the age of 18, for those who are 16 and 17, we're not so much concerned about the days that they're working or the hours that they're working. They just can't work in hazardous occupations. And what is hazardous to you and me? Hazardous to those of us who grew up in Nebraska is not hazardous. It's a different definition of hazardous. There are things that we let farm kids do each and every day that folks at the Department of Labor would deem to be very, very hazardous. Record keeping, to the extent you haven't kept track of the hours worked, pay, everything else. Overtime, here's the general rule. Again, let's start with the foundation. You must assume that every employee in your organization must be paid 1.5 times the regular rate of pay for all hours over 40 in a work week. Each one of those terms in that sentence that I just said are defined. Regular rate is a calculation. Work week, 7 consecutive 24-hour days, however you want to define it. So that's the foundation, unless you can look at the statutes and the regulations and say, we pay overtime, but this person is exempt from overtime, not eligible for overtime. There are a lot of exemptions out there. Some of them were adopted for political reasons. Okay, one of the most recent exemptions was adopted was for Amish woodworkers. Because you know that the plight of the Amish woodworkers is something we all wake up in the morning and say, we must fight for the Amish woodworkers. Anyone want to tell us why Democrats and Republicans came together in just a spark of bipartisanship to protect the Amish woodworkers? Where do most Amish people live?
Pennsylvania.
Pennsylvania, in the country. Good, correct. Pennsylvania, what other state? Iowa, Ohio, Missouri, Ohio, I think has the largest population. Pennsylvania is probably second. What do those states also represent in a presidential election? Just swing states, right? And they all want to curry favor with those states, get those voters. So that's why the Republicans and Democrats came together to create that exemption. There's no rational basis for that exemption. The only ones that so there's a bunch of industry specific ones, just like movie theater operators, cheesemakers, woodworkers. The ones that you will deal with in your workplaces are generally what are called the white collar exemptions. It's in part 541. You really want to research it in the Code of Federal Regulations. It's executive, administrative, professional, and outside sales positions called the white collar exemptions. 3 of those, executive, administrative, professional, have a 3-part test in order to meet those. 1, you must be paid on a salaried basis. What does being paid on a salary basis mean? Receive the same amount of pay each work week, regardless of the quality or quantity of work performed. If I performed any work during that week, whether let's say I made 10 widgets, I get $1,000. I produced 1,000 widgets, I get $1,000. I worked 20 hours, I get $1,000. I worked 70 hours, I get $1,000. That's salary basis. 2, that salary must meet the current minimum threshold, which currently is an annual salary of $35,568. We've got an upcoming development on that. We'll talk about it here in a minute. So you paid on a salary basis. So if they just work that 10 hours, they get the salary. You're not making deductions because they didn't show up the remaining, say, 3 days of the week. 2, it meets that minimum, $35,568. And 3, it meets the duties requirements for either the executive, the administrative, or professional position. Those are detailed. They are gray. That is intentional, in my opinion, because the Department of Labor gets to tell you what they mean or don't. Here's an example. The administrative exemptions. So get paid a salary basis, minimum salary of $35,568 a year. 3rd, it meets the duties test of the administrative exemption, which says that the individual works in an office or non-manual labor position whose duties are generally related to the management of the business or out of serving customers. And 3rd, the exercise discretion and independent judgment with respect to matters of significance. I have no idea what that means. Department of Labor gets to tell you on a case-by-case basis what that means. One thing I think it means is it can't be the receptionist who decides whether to put call throughs or whether to order yellow sticky notes as well as pink ones. That's not a matter of significance. But beyond that, it's a really difficult test. The Department of Labor has fought over the years to provide any more clarity to that because they want to be able to say. So for those of you who came here today or are participating online who thought that we had this question in advance, simply paying someone a salary means you don't have to pay overtime. That is false. For those white collar exemptions, the executive, the administrative professional must be paid on a salary basis. That's one of the factors. It must be the minimum salary of $35,568 a year. Third, it must meet the duties test of either the administrative, the professional, or the executive exemption. So if you don't meet those exemptions, you owe overtime to that individual. We have a case coming up here in a minute, which will show you just how extreme the potential ramifications of misclassifying someone for overtime purposes can be. That's a short synopsis on this very difficult law.
So now that you have that foundation, one of the things that Mark and I thought we would go through next are just some developments that have hit really like within the past year. So in 2023 or later part of 2022. As you know, if you've been working in this space, laws are always changing. So how we have to deal with these updates, we're constantly having to change our policies, change our practices based on different changes in the law. So the first one we want to talk about, actually, that Mark, this one's yours, is Helix Energy Solutions Group.
Yeah, so I mean, we put these in sequential order because these all deal with that law I just talked about, the Fair Labor Standards Act. So this case was just decided by the U.S. Supreme Court last month. So hot off the press, I'm willing to bet that its facts aren't identical to what most of us deal with here in Nebraska. So we had an employee who worked on an oil rig. Rather than being paid on a weekly basis or an annual basis, he was paid on a daily basis. So if he worked on a day, he got a flat amount for that day. And it wasn't just a flat amount, it was $963 a day. If he works an hour on one day, it's $963. Pretty good wages. In the year that was in question, in this particular case, he earned over $200,000 a year. But apparently that wasn't enough for him because he said, "Where's my overtime?" They're like, "Yeah, no, dude, you made over $200,000 a year. You're making $963 a day. Whether you work 1 hour or 10 hours, we're not paying overtime." So he sues. Why does he sue? Let's go back to the lesson I just went over. In order to be exempt under the executive, the administrative, professional, you gotta meet all three of those factors. The parties agreed that he met the duties of the executive because he supervised a bunch of folks that met the standards of that exemption. So that wasn't on the table. So we got the first two. Paid on a salary basis and the minimum salary of $35,568. He met the $35,568, being paid $200,000. So that's off the table. How about being paid on a salary basis? The definition of being paid on a salary basis is you receive the same amount of pay each work week, regardless of the quality or quantity of work performed. The Fair Labor Standards Act, in that instance, focuses on the week, not the day. And so, for example, because his pay fluctuated week in and week out, he didn't get the same amount of pay each work week.
Yeah, because some days he would work 4 days, some days he would work 5 days, some days he would work 2 days in a work week.
And because of that, the court said that's not salary basis. Therefore, employer, because there's a 2-year statute of limitations, 2-year period, for the 2-year period prior to his lawsuit, you gotta go back and pay him overtime. What do you think the overtime rate is if your rate, let's say it is $963 a day, divide that by 10, let's say it's $100 an hour. So they're gonna pay $50 an hour overtime for every hour that that guy worked over 40 for the last 2 years. Doesn't seem like the right result, but it is a technical reading of that statute. Paid on a salary basis. That is one of those 3 requirements. They didn't meet it in that particular case. Here's an interesting, I'm going to completely nerd out on this one. So the decision was 6-3. It's a split court. And one of the justices, Justice Kavanaugh, said, you know, I'm not sure what this whole salary thing is about. We've been using that term since 1939 when the regulations were adopted, after the law was adopted in 1938. But there's nothing in the statute that mentions a salary basis. Whoever gave the Department of Labor the authority to even use the salary basis term? I think it's time for someone to bring a challenge to that. I'd be open to actually saying that the Department of Labor has no salary to even require that you pay someone on a salary basis. Who knows? That may happen in my lifetime, may happen in the next few years. I saw just some readings the other day that someone has started, because of what Kavanaugh said, filed a lawsuit in Texas on behalf of some Dairy Queen franchisees challenging that very topic. So who knows, at some point in the next 5 years, 10, maybe, they may strike down the whole way in which we decide who gets overtime and who doesn't.
Let's do a real quick practical implication of what this salary basis rule may be that would maybe impact you. So oftentimes we'll get calls, probably maybe at least a call a month from a client who says, well, wait a minute, I've got somebody who we've properly classified as exempt from overtime and they didn't show up for work. Can I still ding their PTO bank or their vacation bank for that absence? The answer is yes, assuming that you've got a vacation or PTO policy plan that allows you to do that. Where there's a little bit of nuance to it is, let's assume that that employee that you have has run out of their PTO bank or has run out of their vacation bank. It's really tricky as to whether or not we can dock that employee's pay in that work week for missing that one day. Our general rule would be you cannot dock them their pay for not showing up to work that day if they don't have any PTO or vacation remaining. You can discipline them, but they still must be paid. There's a little bit of nuance to it based on whether it's for sickness or health reasons, but otherwise take away from this. If you've got an exempt employee who's run out of their vacation or PTO bank, they miss a day, you're going to want to address that issue with your employee in terms of disciplining them as opposed to docking their pay for that particular day. Because like Mark said, they have to be paid the same amount each work week, regardless of the quantity or quality of the work that's performed that week.
Next development on this. This is coming down. This is really bad news for all of you if in fact this happens, only because it's going to create a headache for everybody. So some who've been in an HR capacity or own a business to understand that back during the end of the Obama administration, they proposed increasing that salary threshold to be exempt from overtime. Remember, salary basis, minimum salary, currently 35,568, used to be 23,000 something. The Obama administration proposed increasing that to 47,000. Court challenge was instituted. It was successful, struck that down. But the Trump administration came in and said, valid point, that number needs to be increased, has not been indexed, so let's increase it. That's how we currently, as of 2019, have been 35,568. The Biden administration has issued notice that in May, meaning 2 months from now, they are supposed to issue new proposed regulations on that salary threshold. Currently 35,568. It is anticipated that that will go up into the $40,000. And there's at least some members of the Congress who recently sent a letter to Biden's Department of Labor said, we think it should be in the 80s. I will tell you, Tara and I can confirm this, when this came down during the Obama administration, was kind of, it's a last minute deal, right? Nobody was prepared for it. The biggest impact was on nonprofits. You can't just increase the salary of your executive director from, say, 24,000 to 47,000 overnight, right? That takes money away from your programs and things like that. But all of this applies to nonprofits as well. Some businesses can absorb it, right? Rising cost to customers and things like that eventually. Just so you know, keep an eye on this. If you're mid-budget cycle, understand that there may be some mid-year adjustments you may need to make in order to comply with this. There are other ways in which to comply. We, again, if this happens, be more than happy to do another seminar on that. We also do our First Friday webinars, which we'll talk about at the end of today's presentation.
Another update that we want you to be aware of, and when you walk out today, we hope you have some knowledge on, is the Federal Trade Commission proposed rule. So what we know from the Federal Trade Commission is 1 in 5 American workers, or 30 million workers, are bound by non-compete agreements. And what the Federal Trade Commission did is on January 4th of this year, they came down with 3 enforcement cases against 3 different companies who had non-compete agreements with their workers. 2 of those cases were in the food and beverage industry, and 1 was a security guard. So January 4th, there's this announcement. Federal Trade Commission says non-compete agreements in these 3 settings are unenforceable and should not be allowed. The very next day, on January 5th, the Federal Trade Commission came out with a proposed rule where they are suggesting that we ban non-compete agreements in the employment arena. They say that one of the reasons to do this would be it will increase wages to workers if we ban non-compete agreements. In this particular slide, you'll see a picture of the current chair, Lena Khan, of the Federal Trade Commission. she had these two quotes recently this year regarding this proposed rule. One, she says, the freedom to change jobs is core to economic liberty and to a competitive, thriving economy. She also shared non-competes block workers from freely switching jobs, depriving them of higher wages and better working conditions, depriving businesses of a talent pool that they need to build and expand. By ending this practice, the FTC's proposed rule would promote greater dynamism, innovation, and healthy competition. So you might be looking at me and saying, my organization does not have non-competes. Great, hard stop. I can ignore everything that Tara is going to say for the next couple of minutes. I would encourage you to keep listening. The reason is because under this proposed rule, the definitional section of what a non-compete is far more expansive than you would anticipate. So one, the proposed rule says things like, if you have a non-disclosure agreement, think confidentiality agreement, whereby you're saying to your workers, you cannot disclose this type of information when you leave our organization or while you're employed by us. Federal Trade Commission has said, if that non-disclosure agreement acts or functions like a non-compete agreement, such that that worker then really cannot compete in the marketplace in a competitive industry, that non-disclosure or that confidentiality agreement, we're going to consider that a non-compete, and that is prohibited. Similarly, they've got another provision that says if you've got any, we call them training agreements, but if you have any agreements with your workers that say we are going to provide this training expense for you, but if you do not work for us for some period of time after we've paid for this cost, we're going to ask you to reimburse us for that training amount that we paid on your behalf. In the definitional section of this particular proposed rule, they said that those types of agreements, those training agreements, again, if they function like a non-compete and prohibit a worker from going into a competitive business after they leave your employ, that could also be considered a non-compete agreement and unenforceable. So where we're at with this proposed rule right now is the FTC has set this out for public comment. Some of the questions that they've asked the public to chime in on are things like, should franchisees be covered under this particular rule? Should senior executives be exempt from this ban on non-competes? And should low-wage earners be treated the same as high-wage earners as it relates to non-compete law? So this is a development that came out at the beginning of this year. We expect to continue to hear more in terms of what the rule, if any, may be that comes down. I would assume it will look slightly different than the proposed rule that was released on January 5th. But here's what's kind of interesting. If you are an organization that has a non-compete or a confidentiality agreement or non-disclosure agreement that functions as a non-compete and so then would be prohibited under this rule, this rule wouldn't apply retroactively, meaning you wouldn't get in trouble if you had one of these in place before, but it does require you to take certain action. So under the proposed rule as currently drafted, you have to give notice to all of the employees that you previously had one signed to say, hey, this agreement that we previously had you execute is no longer enforceable. And in the proposed rule, it even goes so far as to say, here's the language we would suggest that you issue, and you have to do it on an individualized basis. So you can't just do a mass email to everybody in your organization that says, hey, new rule, if you had a non-compete, it's no longer valid. What the proposed rule tells us is it has to be an individualized communication from you to each of those employees that has one that says this is no longer going to be effective. One of the things that we know from the proposed rule is if this proposed rule does become a final rule and gets enacted, it will become effective 180 days after that rule is enacted. So again, something to be mindful of. And so the question kind of becomes, what do you do now if you are an organization that maybe uses non-competes or non-solicitation agreements, maybe confidentiality agreements, non-disclosure agreements? It'd be our suggestion, you figure out where those are in your organization, reach out to your legal counsel, figure out, okay, is this something that could be implicated? And again, this proposed rule has this exact notice language that you would want to include if in fact this continues to move down through the pipeline.
So next topic, earlier I told you labor law differs from employment law. Labor law deals in the unionized setting. So most of it you don't need to worry about, but just like the last topic, don't close your ears because there's one section in there that applies to non-union employers as well as unionized employers. That's generally referred to as Section 7. It says that all employees, whether you're in a unionized facility or employer or not, have the right to work in concert together for the mutual aid or protection of each other. What this has come to mean is over the course of time, again, since 1935, employees have the right to bring grievances on behalf of themselves, on behalf of other employees, not just a personal gripe, but let's say our benefit plans are not sufficient. The employees believe we need X. That's protected communication. Classic example, and Tara and I review a ton of employer handbooks. There's often a provision, which is, again, this has been illegal since 1935, but we still see them. You are not allowed to discuss your pay and wages with your coworkers. The National Labor Relations Board has said that's unlawful if you do that, because employees should have the right to discuss among themselves what they're being paid, to decide whether they should form a union in order to get more fairness, more equity in their pay rates. Now, obviously, if someone's working in HR payroll, you can prevent them from discussing everyone else's wages that they're privy to. But as far as saying, I make 17 bucks an hour, what do you make? That's protected. You can't do anything to the employee about it.
So if you have a handbook and that sentence exists, you don't have to report back to Mark and I that you have that, but I would suggest you go in and you delete that sentence.
Well, the current National Labor Relations Board, which is a 5-member commission, it's always a majority of the party in power in the White House. So currently pro-labor majority is started to once again expand on these protections. One of the ways he did it was a recent case, which goes on the same issue that Tara talked about, confidentiality agreements. So the labor board has said, when you have a severance agreement, you terminate an employee, if that severance agreement has broad confidentiality provisions that they can't talk to anyone about it, that violates the National Labor Relations Act. If that severance agreement has provisions in there that says that employee, now former employee, can't disparage or say negative things about their former employer, that violates the National Labor Relations Act. That is as expansive of a reading as we've ever seen, at least in my lifetime, certainly since 1935. Other developments of this very aggressive National Labor Relations Board. One, to the extent we have more folks working remotely today, many employers have implemented some type of technology to monitor whether employees are actually working. Makes sense, right? One of them is called keylogger technology, determining whether the employee is actually actively using their computer as opposed to just turning off the camera. National Labor Relations Board said, to the extent an employer is using those types of technologies to monitor employees' productivity, we believe that those things may violate the National Labor Relations Board, and we're just waiting for the right case to say that. Another one, recently, a recent decision by an administrative law judge under the National Labor Relations Board, basic provisions in employee handbooks that we've seen for 100 years that are now saying violate the National Labor Relations Act. In addition to the one we talked at the outset about you can't discuss your pay or wages, that's been unlawful for quite some time. How about provisions that say when you're done with employment, you must turn the handbook in, or you can't share the information in this handbook with anyone else? They say that violates the National Labor Relations Act. Here's the takeaway. Even if you're a non-union business, understand that this very aggressive National Labor Relations Board is expanding its reach into non-union employers. And before you take any action against an employee for complaining about something regarding the terms or conditions of their employment, even on Facebook, protected potentially, make sure you talk to someone who actually practices in this area to make sure you're not unwittingly giving rise to a potential lawsuit. Next one is mine as well. Then I think I'm done for one.
Hopefully.
Just sit down.
Hopefully.
All right. So as much as it's craziness of going on the federal level, those of us in Nebraska have been very blessed, in which we live in a state of generally pretty rational, good folks, right? We just want to serve our communities, do our job, be with our families, we don't deal with a lot of stuff. Hence, all the crazy jury verdicts you see on the coast, California in particular, really haven't made their way here till now. So we generally have not seen huge verdicts in the employment context in Nebraska. As a result, employers really haven't, they certainly get involved in litigation, but the outlying risk is not that significant. Last fall, there was a discrimination case filed against HDR Engineering up in Omaha. It was a sex discrimination case. There was also an element of retaliation and Equal Pay Act. All the laws that they sued under were all Nebraska law, not federal law, Nebraska law. I'll explain why here in a minute. Jury came back with a verdict in favor of the plaintiff on sex discrimination in the amount of $3.8 million. That is a huge verdict. That's even huge in California. For an employee making $100,000 a year, that's a huge verdict, in part because 1.28 million of that was for pain and suffering and emotional distress. Good news is, for those of you who are employers or in HR, is that the employer filed an immediate challenge to that, a motion for a new trial, and just recently the trial court granted that. Why did they say an error was made? Here's why. At trial, the trial judge, he admitted he was wrong in hindsight, allowed the plaintiff to say, well, I was treated poorly, and here's 10 other women who also work for HDR who were also treated poorly by this particular supervisor. The court said, you know, in hindsight, if it's intentional discrimination against you, that's the focus. It doesn't matter how he treated others. That should not have come into evidence. So there'll be a new trial that is had on it. The only point of this is this. One, these jury verdicts, the crazy ones you read about in the press, see on TV, will eventually, and they're starting to make their way here, so the risk is increasing. Two is, she sued under Nebraska law. We're starting to see that a lot more in our practices. Federal law has a cap on compensatory damages, such as pain and suffering. It's $300,000 for larger employers. There is no cap under Nebraska law. So we're seeing more lawsuits filed under our state law, and as a result, there's no cap. We may start to see more of these larger verdicts.
Another key development that we wanted to touch upon, and we just put a couple of headlines as it relates to sexual harassment or discrimination claims. One of the things Mark mentioned was that oftentimes what we see happening on the coast eventually or over time make their way into the Midwest and into Nebraska. And as it relates to sexual harassment, sex discrimination, and training, that would be the case. So a number of states on the coast have implemented laws that say organizations have to conduct regular sexual harassment training for their employees and supervisors. Some states say that has to be done every other year. Some say that it has to be done every year. Some states will say things like you can no longer just purchase a product online and have all of your employees review it as a part of orientation and check the box that they have done the sexual harassment training. Some states are now saying, no, it has to be live in-person training. We don't have any of those requirements in Nebraska yet. I would assume it will eventually make its way there or make its way here. But what we want you to be mindful of is a number of Nebraska employers are starting to implement these types of training into their organizations already. So if this is not something that you've done historically, at least keep it in the back burner, if not on the forefront, as you move forward with this year or next year as to whether you want to do it. The reason is if you do come across that case where maybe a disgruntled employee feels like he or she was discriminated against because of their sex, the fact that other organizations in Nebraska are doing this type of training right now, and if you are not, the question becomes, were you acting reasonably as an employer and making sure that your employees know that you have a mechanism for reporting this type of conduct, that people know what is and is not off limits and how to handle it. We've also seen a fairly significant uptick and the number of times we are requested on behalf of clients to come in and do workplace investigations. So perhaps there's an organization who has an employee who claims that this person feels like they're being treated inappropriately at work from a sexual harassment standpoint. We're doing a lot more of those types of internal investigations. A lot of times those are done by clients yourselves, your HR department, but certain times maybe some of the allegations that exist or maybe who the allegations are about would suggest that someone else should get involved. So we just wanted to put this on your radar as something that a number of Nebraska employers are starting to do, is these specific sexual harassment trainings.
All right, so now we're going to wrap up. We got about 15 minutes left. Again, feel free to ask hypothetical questions if you have any. We're going to go through we've been doing this for quite some time. Some kind of bedrock principles would come up, axioms, if you will. Is we're going to talk about a handful of those that we've kind of developed over the years, just being things that we've done either right or wrong, good advice, things that we've seen. So the first one, I'll let you handle it.
Sure. So the first one, that we put down, if it's not in writing, it didn't happen. Oftentimes when we are called up on by a client because they maybe want to move forward with somebody's termination, they maybe have identified that there's some amount of risk. One of the very first questions you're ever going to hear from Mark and I is, have you documented the performance related reasons or the reasons why this particular employee is not meeting expectations? More often than not, the answer is no, we don't have anything in writing, but everybody in the organization knows that employee Steve is terrible. Steve never shows up to work on time. He's a cancer to the organization. Well, the reality is if it wasn't down in writing, you're going to have some problems, at least from a risk assessment standpoint. So lots of different things that you can do to make sure that something is documented in writing. Sometimes it can be as simple as maybe just an email to yourself that you save in the file. Hey, I talked with Steve today about being late. Told him it's our expectation that he starts showing up to work on time when scheduled, which is 8:30 in the morning or whatever that may be.
The beauty of the email is it's date and time stamped, so that allows you or us or your attorneys to be able to get that into evidence. That's very helpful. That's the reason why it's very quick to send yourself an email or HR or someone to put that on.
Yeah, so like Mark said, if employment at will is the foundation, and then perhaps we say, okay, this particular employee that you want to move forward with isn't in any of these protected classes, we're still going to encourage that we have some sort of documentation in place to substantiate why it is that we're moving forward with terminating an employee.
Next axiom, focus on job duties and expectations, not the underlying or perhaps suspected reason why they are or not getting the job done. So here's the example. How many physicians do we have in the room? Yeah, I'm not one either. Yet for some reason, all my employer clients want to consider themselves to be physicians. For example, John just hasn't been himself lately. He's been at early attendance problems. I think he's got clinical depression. Oh, really? Why do you say that? Well, it's whatever. I saw it in a movie. I read about it. Don't offer medical diagnoses or opinions unless you're in fact a medical provider. Don't worry about at this stage why he is not showing up to work. Focus on his job description. He shows that he must report for work when scheduled in a timely and prompt manner, and he's not meeting that expectation. At this stage, we as your attorneys, you being in any type of management role, don't care as to what the underlying reason is. Now, Joe may, when you counsel him regarding that, may say, got to be as honest with you, I'm currently under medical care for severe depression. Boom. That triggers a new obligation under the Americans with Disabilities Act. At that stage, we can start to go down that track of what's called the interactive process to determine what are the restrictions, can we accommodate, et cetera, et cetera. But don't start out of the gate thinking, oh, I think he's got depression. It literally not a week goes by where a client it doesn't try to give us some rationale. He's been showing up late to work. I think if I'm not mistaken, he suffers from, they'll come up with some ailment that they read about or they think they heard on the street. Don't do it. Don't worry about the underlying reason. Just focus on not meeting the expectations and the expectations that were communicated to the employee.
Next one that we've got for you is before deciding to terminate someone for performance related reasons, pull their past performance review, see what it says. We are all inherently bad at giving constructive feedback. Oftentimes you pull that last performance review and it's either meets or exceeds expectations in every single category. And perhaps you just gave that performance review last month and now all of a sudden you're going to terminate them because they're not meeting expectation. To the extent there's some inconsistencies there, that can raise your level of risk if you decide to terminate that employee. Again, not suggesting that you can't, and certainly not suggesting that you are terminating the person for an unlawful reason. But if their most recent performance review is very, very high, and then you move forward with their termination shortly thereafter, it's at least going to raise questions in that employee's mind as to whether or not the real stated reason you gave them for their termination is the real reason, or they're going to ask themselves, is it because I'm in a protected class? So pull those performance reviews. Another tip that we often counsel our clients on is if you have someone in your organization that does performance reviews, make sure that they're trained to do them. Even lawyers in our office are really bad at this. I wouldn't even say Mark and I are probably perfect, but we have an amazing assistant in our office that Mark and I have worked with for about a decade. I mean, the amount of work that she does for us and how exquisite she is unbelievable, but I've never given her a perfect score. The reason is because we get to do employment law. And so there's always opportunities for someone to get better. If you have multiple people in your organization doing performance reviews, probably want to give some advice on how do you fill those out so that if and when you need to move forward with somebody's termination, you can be at least somewhat assured that their performance review is not going to be inconsistent with the action that you want to take.
The other problem with performance reviews, again, if not properly trained, and we all do this. So let's say it's for the performance review for the last year, last 12 months. The things that are in our head, probably the last month. That's another reason to pull that file, pull that documentation, and look at that entire span that they're being evaluated over, not just that last month. Don't view every termination as a dreaded event. It's likely you are helping them find a position more in line with their strengths, talents, and interests. Isn't that a nice way to say I'm firing you, I'm helping you out? I've had situations, believe it or not, in which I have assisted clients in firing employees. And later, I perhaps ran into one of those employees and they thanked me for terminating. Sometimes employees are performing poorly, whether by poor attendance, simply not getting the job done, because there's a misalignment between what they're really good at and what they're currently doing. But they aren't willing to pull the trigger and actually go look for another job, either internally or externally, because they've grown kind of content, right? Got a salary, I got great benefits, I hate my job, I'm miserable at my job. We're simply helping them make a decision that they actually should be making on their own. And again, don't view every termination as if it's a bad thing. In many circumstances, more than you might think, you're actually helping them out.
Sometimes this comes up most commonly, at least from what we see, as those employees that maybe have been at your organization a really long time, and then at some point they kind of outgrow their position, or maybe they've been promoted, and then at some point they've found themselves in a position where perhaps their skills and talents are not aligned any longer with the position. And so we always encourage clients. Sometimes those employees can become cancers to your organization because folks can look at them and see that they are not maybe pulling their weight in the way that we expect. So we always encourage clients, even though it's a tough conversation, have those conversations with those particular employees, see if there is maybe a misalignment between what they've started to do for your organization, where their skills and talents are. Another one, if you've already made up your mind to separate an employee, waiting to implement usually never makes sense. So this happens a lot. We get calls from clients that say, hey, I've made this decision that I want to terminate this employee. We say, do you have documentation? Answer, yes. What does their last performance review say? Well, I highlighted these performance related issues. And we say, okay, what do you need from us? Do you need some talking points so you can pull the trigger? And a lot of times the client will say, well, I think I'm going to wait till the end of the month. Or I think I'm going to wait till next month because of XYZ. More often than I'd like to have to say, that employee will do something between that period of time where you have mentally made the decision, I need to move forward with the termination, and when you actually move forward with it, that might create extra hoops that you have to jump through. So for example, perhaps you've made the decision that you're ready to terminate this employee. Say, I'm going to do it at the end of the month. So I'll do it in three weeks from now. In that interim time, in those 3 weeks, maybe that employee files for FMLA leave, or maybe discloses to you a disability. And then all of a sudden, what you wanted to do in those 3 weeks, you have to kind of take a pause. You're going to have to jump through some more legal hoops, because all of a sudden they've disclosed to us an impairment, or that they are a part of a protected class. And now we can't just move forward with the decision that we wanted to make. So more often than not, if you've made the decision of, yes, I need to move forward with the termination, it's better to do it then than to wait for some period of time in the future to do that.
Especially when you're firing because of some misconduct at court. We've had those cases whereby, yeah, we discovered he stole, we confronted him, he admitted it. And then like a week later, we ended up letting him go. Why did you not act immediately? We've had those cases with employers like, what do we do? He's been with us for a long time. Let's talk about it next week. And then all of a sudden, in the interim has alleged, I believe I have been discriminated against on X protected class, right? So then you created issues. The courts will say, why didn't you fire someone? If stealing from you is such a bad thing, why didn't you fire immediately? Why'd you wait? Just creates issues. Next one. I like this picture a lot. Tara hates it. When it comes to employee separations, no good deed goes unpunished. We still have clients or employers who contact us who say, hey, this person's worked for us for a really long time. We have documented these declining performance reviews. We have counseled them. That's all demonstrated in the documentation, trying to improve them that just aren't getting it done. And so we're going to let them go today. We're going to pay them a year's severance. Just because they've been here so long, we want to have them have a nice soft landing. Or are you having them sign anything in exchange for that? No. So you're paying them a year, and they can sue you still, right? Oh, they never do that. Wrong. We've had that case time and time again. So when you're going to pay, and it's our recommendation, it sounds harsh, but it's true. When you're going to pay an exiting employee, an employee who's being terminated, anything that they're not legally entitled to, it's not just pay, maybe a positive job reference. It may be not opposing their application for unemployment benefits. It may be something that they really want that's not monetary. If you're going to give them that, get something in return, which is a properly drafted separation or severance agreement that contains, there's a lot of magic language has to go in there. The employment lawyers know there's an evolving area. As I mentioned before, the National Labor Relations Board is starting to chip away at those. So make sure that you have someone who knows what the heck they're doing, help you draft that, get that signed. There's also some magic requirements if the employee is 40 years of age or older. It's a 21-day period under federal law. They must have an opportunity to review that. A 7-day period out, even after they sign, to rescind or to pull back their signature. It's got to have all that magic language to be enforceable. But get one of those if you're going to give them anything of value.
Last thing that we would suggest you do before moving forward with any employee's termination, if you ask yourself no other questions, ask yourself this: before taking an adverse employment action, how would a jury of 12 people view the decision I'm about to make? Because the reality is, hopefully you never find yourself in a circumstance where a jury is deciding whether the actions that you took were appropriate or not. But if you do, it's likely made up of 12 individuals who are employees, who all will be asking themselves whether they should or shouldn't. Hey, what would have I expected my boss to do in this situation? So ask yourself this question. We also tell folks, if we ever have a jury, who do I not want on a jury? It's an HR person, right? It's so easy to second guess decisions that were made after the fact, when at the time, maybe you would have done the exact same. So ask yourself this question before you move forward with any employee's termination.
As we always agree, always in directly on time with a few seconds to spare.
One of the things you touched on it, Mark, but that we do at our office a complimentary we call it a First Friday webinar series. So the very first Friday of every month at 11 Central Time, we offer a complimentary webinar series where we give employment updates to anyone who wants to listen. We have a sign-up sheet if you have any interest in being included on those particular webinars. You'll get an email that says, hey, here's what the topic is this month. You can decide to register. Even if you register, you don't have to watch it live. You'll get an email back where it says, here's the recording of it, and you can listen to it. All of our webinars are also approved for SHRM credit. So if that's something that's important to you, all of them are approved for SHRM credit as well. So we've got a number of people that patch in that are clients, actually a number of attorneys have started patching into the webinars, and then non-clients as well. So you're welcome to.
We think we're pretty funny and entertaining at times too. Sometimes. Any questions or hypotheticals? Yes.
So hypothetically, if they remove the non-competes from being applicable, how does that affect the staffing and recruiting industry? As far as being able to recruit and hire our clients' staff or vice versa?
That's a great question.
Well, what they say is going to happen if this is put into place is that everyone's wages are going to increase, because if you want to retain or get talent, you're going to have to raise your wages. But anything like that would be kind of off limits under this proposed rule, that you couldn't restrict someone from going to work for a client of yours directly or something of that nature.
Any other questions or hypotheticals? Yes.
Could you talk about unlimited PTO bank? That's kind of a new thing.
It is
that
new.
Really popping up, especially in large corporations.
Yeah, so here's stepping back. Vacation, PTO, those are state law driven. There's nothing in the Fair Labor Standards Act that says you have to have paid time off. There's nothing there. So it's all state law driven. Every state is different when it comes to such issues as to whether you have to pay it, accrued unused leave upon separation from employment. Nebraska, after some court cases and some poor legislative drafting, has now landed that PTO on vacation, to the extent is accrued and earned, you must pay that out upon termination, even if they steal from it. You gotta pay it. But sick leave, you don't. That answer differs state by state, but let's focus on Nebraska. As a result of that, we have had clients that have said, well, we're not going to accrue it anymore, meaning there's not leave being placed into a bank. And therefore, when you separate and terminate, you quit, there's nothing for you to take with you. So we don't owe you anything. That is the reason why you're seeing more of those, especially in Nebraska. In our experience, and I think the data proves this, companies that have unlimited PTO, unlimited time off, generally employees are taking less time off. Because there becomes sort of like, well, there's nothing there, I'll try and take time off. And so employers who have a concern about employees just sort of malingering and taking off like 7-week vacations, things like that, it isn't happening so far. And when the employee leaves, you don't have to pay him anything as far as that accrued leave. That's why you're seeing more of it around here.
And clients that we have that have made that shift from maybe going to an accrual bank to now unlimited PTO. One of the things that we usually talk to them about is kind of what is your culture, right? Because if you do have some employees within your organization that are going to abuse that type of policy, I'm not sure that's in your best interest, because again, those can create quite a few fissures within your workforce. But again, depending on what your size of your organization is, what your kind of company culture or organization culture is, it's certainly something you can look at. But obviously it comes with its own set of issues, because everything's fine and well until you do have that employee that all of a sudden stops coming into work on time because, you know, they're taking a little bit of PTO or unlimited PTO the first hour and a half of every day. And then everybody else is having to take over their time of work. So there's kind of a lot of things you have to think about if you make that shift.
Any other hypotheticals or questions? Yes, I'll go. You next. Yeah.
You'll cap PTO, right?
Yeah, so what we recommend, and again, focused on Nebraska for now, for those who don't do the unlimited, you want to cap it. You want language in there that says if you're accruing it, an accrual is recommended, you're accruing so much per pay period. Once you hit a certain cap, you do not earn any money anymore until you use some to fall below that cap. So you know, and your outside auditors, if you have audits, will know what that unfunded liability, that exposure that you have for paying that out to every employee when they leave. It's already capped, hard number. Good question. Now,
So on the non-compete, like how does that go? Or how do they see it working with companies that person leaving is a fairly large monetary hit to that company? Like there's, in the past, you've been able to sue for, whatever you want to say, loss of business or whatever, because most of that stuff is based on relationship or insider information. Like, does that get rid of all that then, or how do you?
It could, so that was the purpose behind one of the questions that they posed to the public is, should we treat high wage earners the same as maybe low wage earners? The reality being, you maybe have that really significant key person within your organization. At least was a question. Under the proposed rule, there was no distinction made between somebody who was a key person with your organization, could take a lot of business, and someone who is just maybe an administrative assistant, for example. There was no distinction. So it could be that all of them come into play. I think there'd still be potentially other claims that could be raised, like a tortious interference type claim, if that worker for you tortiously interfered in an unfair or unlawful way with stealing that business. There potentially still could be a claim there, but all of it could come under the purview of this proposed rule and restrict and prohibit all types of.
I know it won't surprise you that the FTC doesn't know what the heck it's doing on this, right? It's one size fits all. Nebraska case law already treats differently lower wage workers from higher wage, not using that term, but when they're talking about what is the legitimate employer's interest, if you're just an administrative assistant, you're not privy to confidential information, you really want to prevent them from competing with you. They're not really competing by being an assistant for someone else, right?
One other thing that I didn't really talk about with the non-compete section, but just being mindful of, is here in Nebraska, if you have a I'm using the term non-compete pretty loosely. Here in Nebraska, the only type of employment non-compete that's enforceable is one that restricts an employee from doing business with those customers, clients, accounts with whom they actually did business with when they were employed by you and had personal contact. So here in Nebraska, we have a pretty limited scope as to what is enforceable right now in the employment setting, but that would come under this new federal FTC rule if it gets imposed.
How does the new one affect with ownership? You have a non-compete when you sell your business.
Yeah, so that's great. It does not cover that scenario. So those types of agreements that exist when you are buying and selling a business, those would still be okay. Those would not be prohibited under this rule. This is only applicable in the employment setting.
And that's same true for current press law as well. You can have much greater restrictions when it's a sale of equity or business than the employment setting.
Do you consider high and low wage earners? There's a breakdown on that.
Or that it's Washington's going to tell us. I have no idea what they have in their mind. Keep in mind, they think you should get overtime unless you're making 87,000 a year. We may be at that point by the end of the year. Yes.
Can you pay part-time employees different rates for different jobs?
Yes.
The same employee?
Can. So as long as where it creates, so it's part-time, so you're under 40 a week. Yeah, that doesn't create the headache. Where it creates a headache is where, let's say they're working 60, you got 40 hours at rate A, 20 hours at rate B, then you have to do a blended rate for determining overtime purposes. You can have different rates, sure, as long as they're above the applicable minimum wage. One thing I forgot, obviously I forgot a lot today. So when you're maybe confused at time, what law do we comply with? Is it the federal one or the state one? As a general principle of employment law, the law which most benefits and protects the employee is the one that governs. So because Nebraska's minimum wage is higher than federal law, you will apply the Nebraska minimum wage law. Any other questions or hypotheticals?
I have two questions.
Yes.
Now for people who earn tips and stuff like that, is that the same minimum wage?
No, not currently.
And have they even focused on increasing that?
They have. That was an issue of debate when they drafted the language for the Nebraska referendum. On the federal level, it still was a $2.13 an hour. That if you want, we can spend an hour on the tipped wage.
Okay. It's
horrendously complex, unneedlessly so, only because of regulatory changes that occur regarding whether you can do tip pooling, whereby you have people who are, let's say a restaurant in front of the house, back of the house, where they have to pool, what extent any of that is shared with management. again, whether the credit is appropriately given. It's very complex. If in fact you have any modern, either restaurant or any type of business where tipping typically occurs. But on the federal level, it remains at 213. In the referendum, my recollection, they discussed putting that in there, but it does not specifically address the tipped wage in Nebraska. So it remains at 213. Any other questions? On behalf of Flatwater Bank and everyone else, thank you for having us out. Very grateful for the opportunity. And maybe someday we'll be back and do it again. Thanks.